Hello, friends. Good evening. Yesterday, we discussed a very interesting area of Indian Contracts Act, which is consideration. And I told you yesterday that a lot of people get confused in this area of law. And why is it so? Because if you look at the definition of consideration in the Indian Contract Act, it is extremely technical. And the lawmakers have not even given adequate explanations for a normal person to understand what is the meaning of consideration and how does it work in an agreement. And therefore, I try to make it simple for you by giving you very basic and simple examples. And let's quickly revise those things again today so that you have a proper understanding of consideration, and that will build the foundation for today's lecture as well, because today we will take one step ahead and we will try to see one more nuance associated with consideration. So, all right, yesterday, first things first, we know that in order to form an agreement, you need offer, acceptance, and consideration. Okay, and we are discussing consideration currently. We are already done with offer and acceptance. Question is, what is consideration? And to understand that, we'd seen one example yesterday. Let's look at the same example. A offers to sell his pen to B at rupees 10. Now, to understand consideration, you need to firstly know a few points. Number one, in every agreement, both the offerer and the offeree have to make a mutual promise to each other. It means that the offerer will have to promise something, and similarly, the offeree will also need to promise something. All right, this is the basic rule and a mandatory requirement when it comes to an agreement. If both the sides, that is the offerer and the offeree, are not providing mutual promises to each other, then it is not a valid agreement. Let's understand that with the help of A and B example. In this example, A is promising to do something. Similarly, B is also promising to do something. What is A promising to do? To sell the pen to B. What is B promising? To pay rupees 10 to A. This is the first point that you need to remember, that in every agreement, both the offerer and the offeree need to make a mutual promise. All right. Second, consideration is price of the promise. All right. Now, let's break it down. Here we have seen that both A and B are making a promise to each other. Let's find out what is the price of their promise. But before that, we will need to understand what is the meaning of price of promise. Okay. Price of A's promise, price of B's promise. We know that consideration is price of the promise. Hence, we need to understand what is the meaning of this term, price of the promise. All right. So, price of the promise in very simple terms is whatever the promiser is the person who is making the promise, wants in exchange for his promise. So let's say you are the promiser, you promise to do something. When we talk about an agreement, I told you that promises in agreements are not free, they come at a cost. So when you promise to do something, you are expecting something in return for your promise. You're not promising to do something for free. Okay, now focus on this example. Here A is promising to sell the pen. Question: does A want something in return for his promise? Promise is to sell the pen. Does A want something in return for the pen or in exchange for the pen? The answer is yes. What does A want? What does A want? A wants rupees 10 from B. All right. So this is the price of A's promise. Now coming to B's promise. B is promising to pay rupees 10 to A. When B is making this promise, does B want something in exchange for his promise? Or in other words, does B want something in exchange for paying rupees 10 to A? The answer is, of course, yes. B wants the pen, and that is the price of B's promise. We saw that consideration is price of the promise. Hence, this rupees 10 from B and the pen. This is consideration because this is price of the promise. All right. That brings us to our third point. Consideration needs to be mutual. It means that both the offerer and the offeree have to provide consideration. After some time, we will see that it is not mandatory that the consideration should be given only by the offerer or the offeree. Okay, the consideration can be given by a third party also. But let's forget that for now. We will discuss that in detail. I've written this to make it very simple for you. It only means that both the sides will need to provide consideration. Either they are providing the consideration themselves or they are authorizing a third party to provide the consideration on their behalf. But the rule remains that both the parties will need to give consideration. All right. If the consideration is not mutual, which means that if both the parties do not give consideration and if only one party gives consideration, then it is not a valid consideration to form an agreement. And in this context, I had given you one question yesterday. Question was, A agrees to gift his watch to B. Okay, so in this case, B approached A and asked him, will you gift me your watch? This is the offer from B to A. A accepts, saying, yes, I will gift my watch to you. So we have offer, we have acceptance. To form an agreement, we need consideration. In this case, A changes his mind. A does not gift his watch to B. Therefore, B sues A, saying that A has breached this agreement that we had entered into. Okay, so B's contention is that there was an agreement between A and B wherein wherein A had agreed to gift his watch to B. Since he did not do so, therefore A breached the agreement. Now, if you are the judge in this case, you would know that for an agreement, this thing, all the three elements need to be present. You know that there is offer, there is acceptance. Okay, so you will only need to decide if there is consideration. Now, when you have to determine whether there is consideration or not in a particular agreement, what is the question that you will ask? Price of the offerer's promise and price of the offeree's promise. Why will you ask this question? Because firstly, you know that both the parties are making mutual promises to each other, which means that offerer, there's promise made by the offerer, there is a promise made by the offeree. Second point, you know that consideration is price of the promise. Okay, and therefore you are asking this question, that what is the price of the promise which offerer is making, and similarly what is the price of the promise which offeree is making. And you know that price of the promise means whatever the promiser wants in exchange for his promise. All right, so applying that in this case, what is the price of the offerer's promise? Who is the offerer? Who is the offeree in our example? B is the offerer, A is the offeree. A has to gift, A had accepted to gift the watch to B. Okay, question. First thing is, we need to see if both the parties are making mutual promises or not. For that, we will need to see what is the promise by B, what is the promise by A. Let's start with the easier one. What is the promise that A is making? A is making a promise to gift his watch to B. What is the promise which B is making? If you observe closely, you would notice that B is not making any promise at all. And why am I saying so? What do you think? The answer is, let's start from here. You know that A is making a promise to B. The promise is to gift his watch to B. So question is, what is the price of A's promise? Means that what does A want in exchange for his promise? The answer is nothing. A does not want anything in return for his promise. Whenever you see such a scenario, when you see that the price of a promise is nothing or zero, then you can safely say it is not a valid consideration. And as I said, consideration needs to be mutual. Both the sides need to provide consideration, okay, to each other. In this case, in the first step itself, we see that B is not providing any consideration to A. Therefore, this is not a valid agreement. All right. So remember this. And therefore, you would see that whenever you talk about a gift is not an agreement. And today, I hope you understood why. Because in gift, there is no consideration given by the donee. Donee means the person who is receiving the gift. Donor is the person who is making the gift. Since there is no consideration by the donee, therefore, any gift arrangement is not an example of an agreement. So if I promise to gift you my car, and let's say I change my mind and I don't gift the car to you, and let's say you take me to the court for going back on my words. Question is, will you win the case? Simple answer is no, because this was an arrangement of gift. And as we saw, there is, whenever we talk about gift kind of arrangement, there is no consideration by the donee. Okay, and therefore a gift is not an agreement, hence you would not win. Okay. All right, gifts are gratuitous in nature, means that the person making the gift does not expect something in return from the other side. The other side is the person to whom the gift is being given. Okay, now that we have understood all this, question is, okay, while the consideration needs to be mutual, should there be a value of the consideration? Should there be a value of the consideration? Example, A and B. A offers to sell his bike to B at rupees 1. Okay, and the value of the bike is rupees 5 lakh. The current market value of the bike is 5 lakh rupees. But B is offering to sell this bike to, but A is offering to sell this bike to B at just rupees 1. So in this case, what is the price of A's promise? What is A expecting in return? Rupees 1. What is the price of B's promise? B has promised to pay rupees 1. What is B expecting in return? Bike. Now compare this. 1 rupee for the bike. Do you think it's adequate? Is it an adequate consideration? The clear answer is no. Nobody in their right mind would sell a bike worth rupees 5 lakh at rupees 1. So the consideration is not adequate at all. Then the follow-up question is, if the consideration is not adequate, does it become an invalid consideration? If the consideration is not adequate, then does the consideration become invalid? The law says no. Then what is the requirement under law? It is that for a consideration to be a valid consideration, it needs to have some value in the eyes of law. This is what law says. Consideration should have some value in the eyes of law. All right. We will have to understand the meaning of this phrase, some value in the eyes of law. Okay, it looks simple, but actually it is quite complicated. And I won't make it complicated for you. I will try to make it as simple as possible so that you never forget this concept. All right. Now, when I say that consideration needs to have some value in the eyes of law, you only need to ask one question: can the court enforce that consideration? Okay, this is the only thing that will help you answer whether a consideration has some value in the eyes of law or not. Remember this: can the court enforce that consideration? Okay, if the answer is yes, if yes, then consideration has some value in the eyes of law. If the answer is no, then consideration has no value in the eyes of law. Let's take our bike example. In that example, what is the consideration to be given by A? It is the bike. What is the consideration to be given by B? It is rupee 1. Now, if I ask you, is this a valid consideration? What will you do? You will apply this test. You will ask this question: can the court enforce this consideration? Okay, let's take the bike first. After B pays rupee 1 to A, let's say A does not sell his bike to B. A refuses to sell after B has paid rupee 1. Then B files a case against A, saying that A has breached the agreement. Question: can the court order A to give his bike to B? What do you think? The answer will be yes. Court can order A to give his bike to B because the consideration given by B in this case, which is rupee 1 for the bike, has value in the eyes of law. The court sees that consideration as having some value, which is what the requirement is. All right. So this is a valid consideration by B. Even if it is just rupee 1, the court does not care because the requirement is very simple. It is that the consideration needs to have some value in the eyes of law. Some value does not mean an adequate value. The law leaves it to the parties to decide as to what consideration do they want from each other. Okay, the court does not, the court or the law will not go into the adequacy of the consideration. The court will only ask one question: does it have some value? Okay, if it has some value, then it is a valid consideration, provided it also needs to be recognized by law, which is what we are going to discuss now. But the first part is clear, that consideration, even if it is inadequate, does not mean that consideration becomes invalid. As long as it has some value in the eyes of law, that consideration is a valid consideration. First part we understood, having some value means that any value, it could be any value. There is no requirement that the value needs to be fair or adequate. All right. And in the eyes of law, value in the eyes of law, if you look at value in the eyes of law, so I told you that you have to apply this test, can the court enforce this consideration? Simple meaning is, does the court have the power or the ability to enforce? In our bike example, if I ask you, does the court have the power or the authority or the ability to tell A to give his bike? Is it possible to do so for the court? The answer is yes. The court knows that A has the bike, and if the court orders him to give the bike to B, he can certainly do so. So therefore, it is very well possible for the court to enforce this consideration. The court can give that direction to A. Now let's take another example. I make an offer to you. My offer is, if you respect me, I will give you rupees 100. All right. Now, what is the consideration that I am giving you? Rupees 100. What is the consideration by you? Giving me respect. Okay. Now ask yourself, is this a valid consideration? We know that in order to determine whether consideration is valid or not, we need to answer one question, which is that consideration needs to have some value in the eyes of law, which means that court should be able to enforce the consideration. Now in this example, where I tell you that I will give you 100 rupees if you respect me. Question, can the court enforce this consideration? Ask yourself and answer logically. Can anybody enforce, or can anybody force someone to give respect? Is it possible to do so? The answer is no. Even the court is in no position to enforce this. Okay? Nobody can enforce this consideration. Therefore, when the court cannot enforce a consideration, you can say that consideration has no value in the eyes of law. No value in the eyes of law. Hence, such a consideration is not a valid consideration. I can't make it simpler than this. Okay. Whenever you are faced with a question whether the consideration is valid or not, the first step is to answer. The first step is to know this point, that consideration needs to have some value in the eyes of law. Once you know this, then you will need to break this down and apply the test. The test is, can the court enforce that consideration? The consideration that you are determining whether it is valid or not, can the court enforce that consideration? If the court can enforce that consideration has value in the eyes of law. If the court cannot enforce that consideration, it means that the consideration has no value in the eyes of law. Let me give you another example. NLSIU and your example. Let's say you're not able to clear CLAT exam and you are very rich. So you enter into an agreement with NLSIU where you make an offer of 10 lakh rupees to NLSIU, saying that if you give me a seat in your institution, I will give you 10 lakh rupees. Okay. So you make an offer to give rupees 10 lakh to NLSIU if they give you a seat. NLSIU agrees. But later, NLSIU realizes that this is actually a bribe. So they tell you that we won't be able to give you a seat. No matter the money that you're offering us, we will not give you the seat because what you're offering is a bribe. So you sue NLSIU, you take them to the court and you tell the court that NLSIU has breached this agreement. Now the court will need to determine whether this is a valid agreement or not. Court can clearly see that there is offer, there is acceptance. So the only remaining thing is consideration. Okay, so what is consideration to be given by NLSIU? A seat. A seat in NLSIU. Consideration to be given by you? Rupees 10 lakh. Question: does this consideration have some value in the eyes of law? This is what you need to answer, because you know that for a consideration to be valid, it needs to have some value in the eyes of law. Now let's pay close attention here. You are the judge. Can you enforce this consideration? This is the test. Can you enforce this consideration? If yes, then the consideration has value in the eyes of law. If you cannot enforce the consideration, then the consideration does not have value in the eyes of law. All right. Now, can the court force you to pay rupees 10 lakh to NLSIU? Will the court do so? The answer is no, because court knows this is bribing. This is bribing NLSIU and this is an offense of bribery. So the court cannot enforce the consideration because paying rupees 10 lakh for a seat is bribe. So the answer is simple. The court cannot enforce this consideration. Therefore, this consideration, the consideration that you are giving to NLSIU, this consideration does not have value in the eyes of law. Hence, it is not a valid consideration, and therefore there is no agreement. All right?
I found this on the web.
So, you must remember that consideration is valid only if it has some value in the eyes of law. And to understand what does it mean, you need to apply this test. whatever consideration you're talking about, the consideration whose validity you are determining, you need to see, can the court enforce that consideration? If yes, consideration has value in the eyes of law, and hence is a valid consideration. If the answer is no, then there is no valid consideration. All right, I will leave it at this because this is a very, very technical area and I've made it extremely simple for you. So I would want you to spend some time on this. Apply this test. Can the court enforce the consideration? Apply this test to as many scenarios as you can think of. Okay, I can give you one example. Let's say a wife tells her husband that if you go to office today, I will make pizza for you after you come back. Question: is the consideration here a valid consideration? You will need to apply just this test. Can the court enforce this consideration? So, likewise, think about several such examples. Look at real world cases where the consideration is in dispute. Okay, and then you will be able to understand as to how simple I've made this for you. And once you understand this, then nothing in contract law would be challenging for you, because trust me, this is an area which is the most problematic to understand the concept of consideration. All right, tomorrow we will look at some more aspects pertaining to consideration, because uh, consideration needs to consideration has several other requirements as well, which we will need to study in detail. All right, so let's do that tomorrow. Until then, study, revise, and please ask any questions that you want to ask, and I will reply ASAP. Thank you so much.